My name is Pauline Lennard, and this video relates to task 4 of my assignment on the HNC Business with the Thames graduate with regards to Unit 5, Negligence and Contract Law. So the aim of this video is to discuss the tort of negligence as it applies to business situations. So I'm going to look at two specific scenarios and apply the various elements of tort and suggest what defences are available to the defendant. And I will also look at a case of vicarious liability and see what it means, and also what things are available at law. So in the first instance, we're looking at the elements of tort, and so I'm just going to briefly explain what the 4 elements of tort of a tort in negligence are. They are duty of care, where you need to be able to prove that there is a relationship between the two parties and that the defendant has a duty of care. Then you look at the breach of care, whether the standard of care provided went below that which is reasonable, that anybody could expect, a normal person. Causation, you need to look at whether the damage was, you need to look at whether the damage was caused by the breach, but for, so did the damage occur but for the negligence that occurred. And then remoteness of damage, you also need to be able to prove that the damage was directly related to the negligence. So in the first instance, we're going to look at duty of care. So in the specific, the scenario is between two companies. There's Delta & Co. and Johnson & Co. Delta & Co. have got a maintenance contract for computers that they have provided to Johnson & Co. And there have been many problems with the computers, and Johnson & Co. have sued. One of the Delta & Co. employees, the manager who was looking after the computers, has had a breakdown. He's off with stress. And so we're just looking at what this means. So, do Delta & Co. owe a duty of care to Johnson & Co. for the computer failure? And I would argue that yes, it's possible, in fact, for Johnson & Co. to sue Delta & Co. both for negligence, both in contract and in tort. The duty of care arises straight from the contract, and proximity is presumed by the existence of the contract. And the case in tort would arise from the responsibility of Delta & Co. for the terms of the maintenance contract. With regards to the Delta & Co. employee who went off with stress, the Delta & Co. company have a statutory duty through their relationship as employer and employee with their manager. So there is a duty of care here. Next, we're looking at breach of duty of care. So in Johnson & Co., the reasonable standard of care would be that in the course of the maintenance contract, computers issues are resolved, that within a certain scale, and that things sort of turn over. You do expect issues to arise, but that things get resolved. With Delta & Co. employee, there was a breach of statutory duty with regards to the safety and well-being of their employee, who went off with psychiatric harm. Now, the case of Davy v. New Merton Boards Mill, 1959, offers a bit of an insight in that, in the case, the defendant, the company, had given the claimant Davy a tool that looked perfectly fine, but actually had been manufactured wrongly by an otherwise reputable manufacturer that they used all the time. The defect could not have been seen prior to actually it being used, and then the employee was injured. And the court held that in those circumstances, the employer was not liable for the consequences of the manufacturer's negligence. So in this case, Delta & Co. could argue that they did not know that the computers were defective, and so they started to fail, so they couldn't have at all expected the circumstances to have occurred, and they should not be liable for the mistakes of their usually trusted manufacturer. Now we're going to look at causation. And in the case of Johnson & Co., would the damage to Johnson & Co. in lost earnings, additional cost, loss of opportunity, inability to conduct the normal activities of the business, would they have occurred but for the ongoing delays and particularly the lack of resolution in solving the computer issues? And I would argue that the damage to Johnson & Co. was directly caused by the computer issues. With regards to the employee, could the stress that he was under have occurred but for the negligence of Delta & Co. towards him? The scenario suggests that if the issues with the computers had not been so sustained and multiple computers had not stopped working, all in the space of 6 months, there would have been no cause in the manager's duties for him to experience the level of stress that he did, and that caused him to take time off. Therefore, the likelihood is that the harm occurred solely because of the negligence. In this case of negligence, the type of harm is that of psychiatric harm, and in this case, stress at work, and you have got specific duties. You need to be able to assess this in a specific way. In the first instance, you need to be able to distinguish between normal emotional distress, such as normal experiences of expressions of grief and fear and sorrow, and psychiatric harm. And it has been decided in law that stress at work falls in this category. So now we look at the remoteness of damage. And to answer this question, in Delta & Co.'s place, a reasonable person could have foreseen the injury to Johnson & Co. in terms of damage to their reputation and economic losses due to the defectiveness of the products. Now, for this to stick in court, Johnson & Co. need to be able to convince the court that they are owed a duty to safeguard them against this sort of loss, by showing that there was a special relationship between them. And as vendor and consumer, that's definitely the case, as was confirmed in the outcome of Muirhead v. Industrial Tank Specialties in 1985, that said that for pure economic loss, the purchaser can only sue the immediate vendor and not a manufacturer. But Johnson & Co. could also argue that Delta & Co. misrepresented the quality of their computers and sue them for negligent misrepresentation. But obviously they will also be able to prove that there is a warranty within the contract that refers to that makes it into a misrepresentation, and the contract actually contains a warranty or even a condition as to the newness of the computers. The computers were supposed to be new, and so this case may actually hold in court. But with regards to the Delta & Co. employee, there's no doubt that the manager took time off stress as a direct result of the pressure he was under, compounded by the fact that Johnson & Co. didn't treat the Delta & Co. employees with courtesy, and they didn't give adequate time to repair the computers. And so as a reasonable person, Delta & Co. should have foreseen this injury to their employee as far as their responsibility extends to it. They should have checked that their technical staff were in fact competent enough in light of such difficulties as well. And there is a case for Johnson & Co.'s behaviour to have exacerbated the problem. This could be argued in the case of Johnson & Co. when assessing damages. And we'll look at that in terms of what defences are available to Delta & Co., which is what we're going to do now. So the first defence that is available to Delta & Co. is that of voluntary acceptance of risk, which in Latin is which is used a lot in legal matters. It's known as volenti non fit injuria, which literally means that no injury is done to one who consents. So for this defense to work, the defendant must prove that the claimant was aware of the risks involved and agreed to suffer them voluntarily. So one clear example of volenti is in practice is when patients sign a consent form before an operation, so that they're aware of the risks, but they also know why the operation is still preferable. Now, for business, one really good case that highlights this is Imperial Chemical Industries v. Shapwell, 1964. The plaintiff was employed by the defendant as a qualified shot firer in a quarry. He and his brother had to test the electric wiring connecting explosive charges, and they ignored the instructions that said they had to do this under shelter, and instead they did it in the open. They had reasons for it, but they decided to ignore the instructions, and they were both injured when charges exploded. And they claimed against their employer based on their employer's vicarious liability for negligence and breach of statutory duty. And the defendant used the doctrine of volenti non fit injuria, i.e. the plaintiffs, they had full knowledge of the risk and acted against express instructions. And initially, at the first trial, they said that volunty was not a sufficient defense against statutory duty of the employer, and but the case went to appeal, and the appeal was upheld. So the ruling then decided how the parameters of the volunty defense, which is to do with the statutory duty. So in this case, the employer had been key in the implementation of the statutory regulations, and had even dismissed the worker before because they hadn't followed the instructions they were given. And so, whereas here there was a deliberate action by the claimant to disobey the instructions, so they knew the risks, and therefore they were liable. Now, so it all depends on whether the employer was actively following his statutory duty, or whether they were being negligent in that matter. So in the case of what's it called, Imperial Chemicals, the company was actually really, really good at applying their statutory duty, and so that's why volunteer worked, because their workman was aware of what's going on. Now, in terms of Delta & Co., the manager obviously knew the consequences of not resolving computer issues. However, it can't be said that he voluntarily accepted the risks to the degree to which they occurred, especially in light of the statutory duty, which, in my opinion, the employer failed to provide for. Now, another defence that is available is contributory negligence, and that is defined in Street and Home Tort 2012 as a failure by the claimant to take reasonable care for his own safety that contributes to the damage about which he complains. And so nowadays, damages can be recovered between the two parties. So if it's shown that they both contributed to the damage or the injury, they both have to pay a proportionate amount of damages, depending on how much that is, and that is for the courts to decide. And now, also, obviously, you need to prove the extent of the claimant's involvement, as in Lister v. Romford Ice and Cold Storage, 1957, whereby the claimant's son was driving one of his employer's lorry and ran over his father, who was also an employee of the same company. And the father sued his employer for vicarious liability and recovered damages, but then the insurers of the company sued the son, claiming that he had contributed to the injury and should pay them damages for what they paid. So it's just a bit of a complicated situation here. And the rule of law is that the employer, who had been made vicariously liable, was entitled to claim an indemnity from the employee if it was shown that the employee was partly at fault. But if the employer is partly at fault, they will only get partial indemnity. So how we apply this to Delta & Co? Well, we'll look at the part of the employee in the tort that's occurred. So whilst the duties of the manager fell within the scope of his role, the workload definitely went beyond that which can be usually expected, both in terms of scale and duration. Now, the employee should have raised the issues with his manager, and the escalation should have been plain enough that Delta & Co, as an employer, should have been aware of the growing risk of ill health to their manager, and they should have taken steps to resolve the issues. They could have attended the Johnson & Co premises to discuss the issues with them. They could have put a plan in place to resolve them. They could also have provided additional help to the manager by spreading responsibility or assigning additional technicians. Therefore, they didn't fulfill their statutory duty to the employee with regards to safety as per Health and Safety at Work Act 1979. However, it's agreed that the stress was compounded by the negative experience of the workers at Johnson & Co premises and the lack of time given to provide adequate service to the computers. And that cannot be attributed directly to Delta & Co. And so the employee actually would have a claim against Johnson & Co. for contributory negligence in this case. And if they're able to prove not to be 100% at fault, there may be a reduction in liability and damages will be reduced. Okay, next we are going to be looking at applying the elements of vicarious liability. And for this, I need first to explain what the elements of vicarious liability are. So first, you need to be able to prove the relationship between the employer and the employee. Then you need to be able to prove that the offence took place during the course of employment. And finally, there are the statutory duties of the employer and the employee to take into account. So the scenario in this case is, if I can find them, that there was an employee of Johnson & Co. who was injured due to the negligence of Delta & Co. employee during the course of the aftercare service. Delta & Co. refused to pay compensation to the injured employee of Johnson & Co. on the grounds that the employee was injured at Johnson & Co. and the injury was caused by the careless act of one of the staff of Johnson & Co. So, first we look at the duty of care, and we see that the negligence of a Delta & Co. employee caused injury to Johnson & Co. employee, but they have a contract, they're contracted to each other, so they have a duty of care. Remoteness of the damage, we see that a reasonable person could have foreseen an injury if a computer fell, if there was damage in the aftercare. These sort of natural things that happen are directly linked. And the injury wouldn't have occurred if the Delta & Co. employee had not been negligent, regardless of whether it was partly caused by a Johnson & Co. employee. If it was actually a result of negligence, then there is definitely a direct cause. And next, we apply the vicarious liability principles to the case, and we see that Delta & Co. refused to pay compensation on the grounds that the employee was injured at Johnson & Co. premises. In my opinion, that is actually irrelevant. Employers are vicariously liable for their employees' torts wherever they might find themselves in the course of their employment. Now, in terms of a maintenance contract, it's understood that the maintenance will be undertaken in other people's premises. Therefore, it doesn't matter when the employer is responsible for ensuring that their employees follow the appropriate safe procedures wherever they go. They carry that with them, that responsibility. So in my opinion, they are still vicariously liable to pay damages. The other reason they stated was that the injury was caused by the careless act of one of the Johnson & Co. staff. And as we discussed earlier, one of the defences is contributory negligence, and in this case, it totally applies. If both Delta & Co. employee and the Johnson & Co. employee were involved in the therefore contributing negligence applies in this case. I mentioned earlier that the employer is responsible for ensuring that their employee follow the appropriate safe procedures. That's actually one of their statutory duties that comes from the Health and Safety at Work Act 1974. Section 2.2a says that the employer must provide and maintain the plants and systems of work that are so far as reasonable practicable, safe and without risks to health. And section 2.2c says they need to provide the necessary instruction and supervision to ensure the health and safety at work of their employees. Therefore, they need to, all of their employees need to be sufficiently trained that they aren't negligent when they conduct their duties on other premises. So it is actually the employee's responsibility to ensure that's the case, and they are therefore vicariously liable and should pay damages to the employee of Johnson & Co. at a reduced rate with the Johnson & Co. Who are also vicariously liable for the acts of their own employee in the negligent tort that occurred. Thank you.